Hello friends, welcome to our channel. Friends, today we will see multiple choice question of Evidence Act. Friends, watch our complete video, like it, share it, comment on it. Don't forget to subscribe our channel. So friends, we will see MCQ of Evidence Act with answer. Question number 1. The term admission is defined under dash. Answer is option number D. Section 17 of the Indian Evidence Act. Question number 2. Which of the following statement hold true for dying declarations? Answer is option number D. When eyewitness affirms that the deceased was not in a fit state to make the declaration, medical opinion cannot prevail. Question number 3. In which of the following cases the evidence given by the witness will not be relevant under section 33 of the Indian Evidence Act? Answer is option number A. When the witness is staying abroad. Question number 4. Accused wants to submit a document for consideration under section 35 of the Indian Evidence Act. In which of the following cases will the document become irrelevant? Answer is option number C. It is not an entry made in public or other official book, register or record. Question number 5. A party wants to set aside a judgment under section 44 of the Indian Evidence Act. In which of the following circumstances can he do so? Answer is option number A. In case the judgment was passed by a superior court. Question number 6. According to section 61 of the Indian Evidence Act 1872. Answer is option number D. The contents of document must be proved either by primary or secondary evidence. Question number 7. Definitions of secondary evidence has been given under dash of the Indian Evidence Act. Answer is option number C. Section 63. Question number 8. B. An accused wants to submit carbon copy of the suicide note as secondary evidence. The original is with the opposite party and he has failed to produce the same. The suicide was not within the knowledge of the accused prior to the receipt of carbon copy. Which of the following statement will hold true for the case? Answer is option number D. The evidence can be admitted as it satisfies the requirements of both section 64 and section 65 of the Indian Evidence Act. Question number 9. According to section 65 of the Indian Evidence Act, the secondary evidence can be admitted in dash exceptional cases. Answer is option number C. 7 exceptional cases. Question number 10. Which of the following sections of the Indian Evidence Act gives provision regarding proof as to electronic signatures? Answer is option number B. Section 67A. Question number 11. Which of the following sections of the Indian Evidence Act deals with proof of other official documents? Answer is option number A. Section 78. Question number 12. Which of the following sections of the Indian Evidence Act has been amended by the Criminal Law Amendment Act 2013? Answer is option number C. Section 119. Question number 13. Which of the following statements hold true for section 154 of the Indian Evidence Act? Answer is option number C. The court can give the leave under this section suo motu. Question number 14. Which of the following questions is proper under section 148 of the Indian Evidence Act? Answer is option number C. If they are of such nature that the truth of imputations touches the credibility of the witness. Question number 15. During the cross-examination of the witness as to previous statement made before the police, almost all contradictions or omissions were brought on the record, which were which were portions from the statements made before the police that were not deposed before the court. Which of the following statements will apply to the case? Answer is option number C. The credibility of the witness has not been impeached because the contradictions were not as contemplated under section 145 of the Indian Evidence Act. Question number 16. A person summoned to produce document. Answer is option number A. Does not become a witness in the case unless he is called as a witness. Question number 17. Which of the following statements hold true for examination in chief of a witness? Answer is option number B. It must only relate to relevant facts. Question number 18. Dash. Section of the Indian Evidence Act was inserted by the Criminal Law Amendment Act 2013. Answer is option number B. Section 53A. Question number 19. An admission is not relevant in a civil case if it is. Answer is option number C. Made under circumstances from which the court can infer that the parties agreed together that evidence of it should not be given. Question number 20. Opinions of an expert expressed in a book commonly offered for sale cannot be proved by the production of such book. Answer is option number D. If the author has gone abroad on vacation. Question number 21. Which of the following section of the Indian Evidence Act does not apply to interrogations by a custom officer exercising power under section 171A of the Sea Customs Act? Answer is option number B. Section 132. Question number 22. Which of the following section prescribes the method by which signature can be proved? Answer is option number D. Both A and B, means option A section 45 Indian Evidence Act, option B section 46 Indian Evidence Act. Question number 23. Which of the following is true of the effects of admissions? Answer is option number D, means all of them. Option A. An admission constitutes a substantial piece of evidence in the case and for that reason can be relied upon for proving the truth of the facts incorporated therein. Option B. An admission has the effect of shifting the onus of proving to the contrary on the party against whom it is produced, with the result that it casts an imperative duty on such party to explain it. In the absence of a satisfactory explanation, it is presumed to true. Option C. An admission in order to be competent and to have the value and effect referred to above should be clear, certain and definite and not ambiguous, vague to be true. All of them. Question number 24. An attesting witness is. Answer is option number C. Both A and B, means option A. One who signed his name to an instrument at the request of the party or parties for the purposes of proving or identifying it. Option B. A witness who has attested the document. Question number 25. A intentionally and falsely leads B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterward becomes the property of A and A seeks to set aside the sale on the ground that at the time of the sale he had no title, applying section 115 Indian Evidence Act. Answer is option number C. He must not be allowed to prove his want of title. Question number 26. Admissible evidence is thus that which is. Answer is option number D. Both A and B means option A relevant, option B not excluded by any rule of law or practice. Question number 27. A is accused of crime committed by him at Calcutta. He produces a letter written by himself and dated at Lahore on that day and bearing the Lahore postmark of that day, applying section 21. Indian Evidence Act, which of the following is possible? Answer is option number C. The statement in the date of the letter is admissible because if A were dead, it would be admissible under section 32, clauses 2. Question number 28. A is tried for a riot and is proved to have marched at the head of mob. Applying section 9 Indian Evidence Act. Answer is option number B. The cries of the mob are relevant as explanatory of the nature of the transaction. Question number 29. A sculptor agrees to sell to B all my modes. A has both models and modeling tools. Applying section 98 Indian Evidence Act. Answer is option number C. Evidence may be given to show which he meant to sell. Question number 30. Entry in the Monzavari registered is admissible under. Answer is option number B. Section 35 Indian Evidence Act. Question number 31. Question number 31. In criminal cases under section 54 Indian Evidence Act, to prove that the defendant committed the crime charged, evidence may not be given that he. Answer is option number D. All of them means option A. Bore a bad reputation in the community. Option B. Has a disposition to commit crime of that kind. Option C. Had no other occasions committed particular acts of the same class evincing such disposition. All of them. Question number 32. In which of the following cases did the court held that a party who produces a witness in court produces them as witnesses of truth and simply because portions of their statements are not favorable to the party producing them, they cannot be condemned as biased witnesses? Answer is option number C. Gulabchand Ganbhirmal versus Kudilal Govindram. Question number 33. In which of the following proceeding of domestic tribunals and departmental inquiries the Indian Evidence Act is not applicable? Answer is option number D. All of them means option A. Officers conducting departmental inquiries. Option B. Departmental proceedings. Option C. Disciplinary proceedings tribunal. All of them. Question number 34. Proviso 1 to section 33 Indian Evidence Act not only covers cases of privity in a state and succession of title, but also cases where which of the following conditions is met? Answer is option number D. Both A and B means option A. The interest of the relevant party in the second proceeding is the subject matter of the first proceeding and is consistent with and not antagonistic to the interest therein of the relevant party to the first proceeding. Option B. The interest of both in the answer to be given to the particular question in issue in the first proceeding is identical. Question number 35. Relevancy of facts forming part of the same transaction is dealt under which of the following section of the Indian Evidence Act? Answer is option number B. Section 6. Question number 36. Section 132 of the Indian Evidence Act does not apply to a statement made by a person during an investigation under. Answer is option number B. Section 161 CRPC. Question number 37. Section 31 Indian Evidence Act declares. Answer is option number D. Both A and B means option A. that admissions are not conclusive proof of the matters admitted, but they may operate as estoppels. Option B, unless admission are contractual or unless they constitute estoppels, they are not conclusive but are open rebuttal or explanation. Question number 38. Section 65 Indian Evidence Act, with which of the following situations under which secondary evidence can be given? Answer is option number D, all of them, means option A, when the original is shown or appears to be in possession and power of the person against whom the document is sought to be proved. Option B, when it is in possession or power of any person who is out of reach or not subject to the process of the court. Option C, when it is in the possession of any person legally bound to produce it, but he fails to produce it, and produce it after the notice mentioned in section 66 Indian Evidence Act is given to him. All of them. Question number 39. The defense of alibi is best because. Answer is option number A. If the accused was not there when the deceased was murdered, he could not have murdered her. Question number 40. An estate called the Rampur Tea Estate is sold by a deed which contains a map of the property sold, applying section 92 Indian Evidence Act. Answer is option number C. The fact that land not included in the map had always been regarded as part of the estate and was meant to pass by the deed cannot be proved. Question number 41. Which of the following is the way to assess damage under section 12 Indian Evidence Act? Answer is option number D. All of them, means statement first, the damage suffered should be near as possible to the sum which will put the injured party in the same position as he would have been if he had not sustained the wrong for which he was awarded damages or compensation. Second, damages are usually assessed on the basis of actual loss suffered and are called general or ordinary damages. Third, where the plaintiff has not suffered any real damages by reason of breach of contract, normally nominal damages are awarded. Fourth, special damages can be awarded for personal inconveniences or physical discomfort caused by the other party. All of them. Question number 42. The history sheet of an accused person kept in the police station is not a man's character as it is based on. Answer is option number B, hearsay. Question number 43. The principle on which a dying declaration is admitted in evidence is indicated in legal maxim. Answer is option number A, nemo moriturus prosumitur mentor. Question number 44. The principles of section 44 Indian Evidence Act cannot be extended to each of the following. Answer is option number A, misrepresentation or undue influence. Question number 45. Section 15 Indian Evidence Act deals with a particular application of the general principle laid down in. Answer is option number D, section 14 Indian Evidence Act. Question number 46. The question is whether A poisoned B, applying section 6 Indian Evidence Act, which of the following facts can be relevant? Answer is option number B, the state of B's health before the symptoms ascribed to poison and habits of B known to A, which afforded an opportunity for the administration of poison. Question number 47. To invoke the doctrine of estoppel, which of the following condition must be satisfied? Answer is option number D, all of them, means option A, representation by a person to another. Option B, the other shall have acted upon the said representation. Option C, such person shall have been detrimental to the interest of the person to whom the representation has been made. Question number 48. What do you understand by admission of execution? Answer is option number D, none of them. Question number 49. Under section 82 Indian Evidence Act, the court must presume. Answer is option number C, both A and B. Means option A, that the seal or stamp or signature is genuine. Option B, that the person signing the document held at the time when he signed the judicial or official character he claims. Question number 50. What do you understand by libelous character? Answer is option number A, constituting or containing a libel. So friends, these are MCQs of Evidence Act. Thank you.